I forgot. I always forget something. When we were talking about the features of the legal system, I left out a couple of things in the heat of battle, in the rush of excitement of trying to get through all this. I forgot a couple of things that you really ought to know about. In the Supreme Court sits in terms, one for each year. We are now in October term 2011. Each term begins on the first Monday of October, by tradition, year after year after year, when the court first meets in that term, and then over the course of the next 9 months, the court decides all of the cases that it hears this term. It usually wraps up its term at the end of June. So for the term of court that we're in now, the court will decide all of the cases, including the FCC indecency case and the Medal of Honor liar case, both of which we'll consider. They'll decide those by the end of this term. The Supreme Court's jurisdiction, like that of the California Supreme Court, is discretionary in the sense that the court doesn't have to hear all of the cases that are tendered to it. Please take this case, it's of nationwide importance, and so on. As I said last week, they only hear these days, they whittled it down to 70-some cases that they hear each term. That's of a universe of 9,000 or so petitions for certiorari that they are presented with. They deny certiorari, that is, refuse to hear the overwhelming majority of cases. Then on the common law, I'm not sure, I hope you've grasped what it is, but it was, back in when we were colonies of England, it was the law of England as developed by English judges deciding cases in this incremental way, where the court would build on precedent from previously decided cases and either extend the law to meet new facts and different wrinkles and so on, look to the principle established by the first case and then see whether it should apply in the second case. Using the common law method, the courts elaborated rules of law that governed most relationships between human beings. Contract and tort and criminal law even was a matter of common law back in England at the time our independence was won. And the law of the colonies was the common law of England. So everybody knew what the law was. It was the law decided by those English courts. Well, then when we became independent, when we became states instead of colonies, the states simply adopted the common law of England as the state's own law. For example, New Hampshire, when they enacted the New Hampshire Constitution, the state simply adopted the common law of England as the law of New Hampshire. But it wasn't static at that point because it's in the nature of the beast, it's in the nature of the common law to be organic, to keep on moving, to have life. And so the law wasn't frozen as of 1787 or 1776, whenever it was, when they adopted their constitution. Rather, each state was free to develop its own common law. And there you get, over the ensuing 200 plus years, you get some differences from state to state, even though the courts are following the common law method and building on rules established by common law. The courts come to different conclusions in different states. So the law of California is not necessarily the same as the law of Nevada, the common law. Of course, most law these days is statutory. That is, statutes, laws enacted by legislatures rather than judge-made law. So there's that. Now, let's observe the common law method at work in the case of Morse versus Frederick. Aaron, what's up?
Back to the point you made about terms. If the Supreme Court hears a case, let's say in early June or late May.
Yeah, they won't hear one that late. They quit hearing argument, I think, in April. So they've got to decide within 2 months then. In a rare case, they'll hear argument later. And one of the rare cases is the Pentagon Papers case, which we'll consider in a couple of weeks, which was an emergency situation where the court heard argument in June and decided it a few days later. But that's not the norm at all. Usually, by about now, they have granted or denied certiorari in about all the cases that they're going to deal with this term. And they set them for argument later in the spring. Okay, Morse versus Frederick. Catherine, what was the case about? Just what happened in the case? Factually. Advocates the use of what? Mm-hmm. Which court? Who sued who here? Frederick was suing Morse, right? Joe Frederick, the student, was suing the principal. Was the case civil or criminal? Because the state's not one of the parties? Yeah. There were no criminal charges involved, that's true. But how can you tell generally whether a case is civil or criminal? Tina? Yeah, he was suing for damages. And what else? Can't hear you. Right. He wanted declaratory relief, that is a declaration from the court that he was right and she was wrong, that he did have a First Amendment right to unfurl his banner. That's declaratory relief. You can file that away and forget about it. He wanted injunctive relief, that is, he wanted a court order directed to the school district saying that they can't stop students from doing what he did. And he wanted damages. And you guys have put your fingers on how you tell the difference between a civil case and a criminal case. You look to the parties, who the parties are, and you look to the relief that's sought in the case. And you can't have a criminal case unless the government is one of the parties. In California, it's the people versus Joe Blow. It's the people of the state of California. The government is a party. You can't have two private parties like Joe Frederick and Deborah Morse involved in a criminal case. They're not the government. But you have to look beyond who the parties are, because the government can get involved and does get involved frequently, all the time, in civil litigation where the government brings a civil suit against somebody. So it'll be, for example, in an antitrust case or in a securities fraud case. It'll be the United States of America versus Joe Blow. And you can't tell from looking at that title whether it's a criminal case or a civil case. So you look to the relief that's sought. And if the relief is civil type relief, that is an injunction, damages, so on, then it's a civil case. If what the government wants is to put you in jail, if they want criminal relief, criminal punishment, which could include a fine, then it's a criminal case. That's simple. So here's Joe Morse's banner. This all happened exactly 10 years ago today. The Olympic parade went to Juneau and with a torch, and Joe Frederick unfurled his banner. Catherine, where was he? Yeah? What time of day was it? Does that make any difference? Why? During school hours. Yeah. Yeah, well, you see in the opinion there was an issue. He claimed that this wasn't at school, that he wasn't physically in school, and that this wasn't a classroom where students there might be different rules that would apply in a classroom than out on the street. The court rejected that, saying that it was a school-sponsored event. They were there under the supervision of the principal and the other authorities and so on. By the way, did the case go to trial? Was there a trial in this case? Was there testimony and evidence, and the jury or the judge decided something after trial? No, there was. Well, how did it get to the Supreme Court then? Because what the school district did when confronted with Frederick's lawsuit was gather some information through the discovery process and then make a motion for summary judgment. That is, a judgment summarily entered because all of the facts of the case are undisputed, the relevant facts are undisputed, and the school district claimed it was entitled to judgment as a matter of law. In other words, there was no point in having a trial because the facts were clear, and as a matter of law, the school district wins. And the judge granted that summary judgment. Then, as Catherine points out, the Ninth Circuit reversed that, and the school district went to the Supreme Court, which reversed the Ninth Circuit. So how did these judges on the Supreme Court vote in this case? This was a different court than we have now. Still on the court in 2007 was John Paul Stevens and David Souter, who have been placed by the Obama appointees Sotomayor and Kagan. Then they were the only two replaced. I have to say that those appointments had little and probably no effect on the political lineup in the court, because Stevens and Souter, although both appointed by Republican presidents and nominally Republicans, came to be what passes for liberal on the Supreme Court. So when the Obama appointees replaced the two of them, not much changed politically. So who wrote the majority opinion here? Chief Justice Roberts. And there were some concurring opinions, and they are noteworthy. They tell you things about the individual justices. Clarence Thomas, who's looking sideways up here, wrote a very interesting concurring opinion, concurring that the school district wins. And look at his reasoning. It's basically his view. You have to realize this about Thomas. He's an originalist in the sense that he thinks that the United States Constitution should be interpreted the way the framers of the Constitution understood it. The original understanding is what is important. So he wrote this opinion, which delved into colonial and revolutionary era history, and found to his satisfaction that the framers of the Constitution wouldn't think that school children had any free speech rights at all. And the theory that he used in Latin is in loco parentis, that the school officials, that is Deborah Morris, stands in a relation of in loco parentis to the students. That is, that the teacher, the school authorities, are, while school's in session, in the same role that parents have. And in Thomas's view, parents have complete control over what their students, what their children can say and do. And therefore that's transferred by in loco parentis to the school officials while they're at school. And the net result of that is that students don't have any First Amendment rights at all. He says, in my view, the history of public education suggests that the First Amendment, as originally understood, does not protect student speech in public schools. He poses a question, well, actually, let me pose the question toward the end of his opinion, where he says Frederick asserts a constitutional right to utter at a school event what is either gibberish, blankets for Jesus, or an open call to use illegal drugs. It would be farcical to elevate such impertinence, he says, to the status of constitutional protection. How do you answer that? Yeah. How could the school be responsible for him? Yeah, but the question that Thomas is putting to you is, look, this guy puts up a sign that is either gibberish, he basically says doesn't mean anything, I just wanted to get on television, or it promotes illegal drug use among students. How can there be a constitutional right in a school student to do that? A right that the school officials have to respect. I mean, isn't that unanswerable? Thomas is right. Huh? It's a farce. They can't make a farce out of the First Amendment to say that the kid has a constitutional right to do that. Right? No, you're not. Does everybody agree with that? Yeah. Mm-hmm.
I think it's interesting that he's claiming that gibberish wouldn't be protected as a constitutional right, because I wonder if, like, you don't throw up a sign, it's just like a series of letters and numbers. I hope that would be, like, okay for legal enforcement, that sign said nothing. Whereas I understand, like, illegal drug use and promoting that could be potentially harmful to students. I don't think that it really serious, but I think that should be upheld as, like, within your rights.
Mm-hmm. So we have a constitutional right to utter gibberish. Mm-hmm.
Maybe like an extreme stretch, but if you're saying that parents have like ultimate authority over their children, and you're transferring that authority to the school officials, aren't you kind of infringing on the constitutional rights of parents? You know, like if parents will like I told my kids before I was doing something, and then the school doesn't.
Yeah, that's an interesting point. It'll come up again in the violent video games case that we'll consider later on, where Thomas made exactly the same point that he's making in Morse's case. And of all people, Justice Scalia, his fellow originalist on the court, said in the violent video games case, yeah, but there are a lot of parents out there who would be happy to have their students, their children have these video games. And you're interposing the government between parent and child. And I think that's close to the point that you're making, Robert.
Yeah. You know, it's been a argument for him. You know, would it then be the school's, duty to, instead of possibly bringing up, the person that's like whether it's gibberish or not, would it be the school's possibility to use that, as an opportunity to, say, look, this happened. It seems to be advocating for this, and why you should do it. Should they be parenting instead of
Punish? What, the parents are entitled to punish?
No. Should they be parenting it instead of teaching instead of forcing your values on somebody?
Well, but would you want the courts enforcing their values on school districts and saying, look, your policy doesn't really make sense. You should be acting more like an understanding, tolerant, loving, caring, kind parent rather than a God-fearing type hell and damnation kind of parent. You don't want the courts dictating that, do you?
But my point is that you're also ridiculous.
And therefore it's protected speech? Well, I think that's the right way. The question, in my view, I'm sort of making this up as we go along, the question is not whether there's a constitutional right to utter gibberish. It's a question of whether the government has the power, legitimately under the First Amendment, to punish speech that's just gibberish. I mean, a lot of what we say is gibberish, right? We say it all day long to our friends, to various people. All of a sudden, that's not protected speech? That's odd. Tina?
I think that Justice Stevens directly addresses that question in his dissenting opinion. He comes right out and says that in his judgment, the First Amendment protects free speech if the message itself neither violates a permissible rule nor expressly advocates for conduct that is illegal or harmful to students. The first thing, even if you're saying gibberish, that's not necessarily violating any rules. And in the majority opinion, the court itself called the message cryptic. And even if it is somehow promoting illegal drug use, which if the court is calling it cryptic, that's not a foregone conclusion. He cites Brandenburg and says that mere advocacy isn't the same thing as inciting to, I think there's in the law of action. That's the catch that should be applied to free speech, even in the school setting.
I'm persuaded by that. But Stevens backs away from that a little bit later. I mean, he establishes these important principles that you mentioned, like Brandenburg, for example, which is an unbelievably important case that we'll consider in detail in a couple of weeks. But then he says, even if students don't have the full First Amendment rights of adults, still, Frederick should have won his case. So those principles have full application to us, grown-ups. But it seems that they have limited application to school children, and even Stevens has to recognize that. John, do you have some? Okay. Then there's another concurring opinion, and this one was vital to the result because Roberts didn't have the votes without the concurring opinion, without the concurring votes of Alito and Kennedy. Alito, another very conservative appointee of George W. Bush, very religious, serious Catholic, and very conservative. And Kennedy joins him in this concurring opinion on the grounds that the court's decision doesn't mean any more than that a public school can restrict speech that a reasonable observer would interpret as advocating